Respected ma'am and dear participants, a very good evening to all of you. I, Rishavraj, member of Legal Vidya, welcome you all to this course. So, without any ado, let's begin the class.
Good evening, Legal Vidya, and good evening, all the participants present over here. So, today we will start the session. Wait for a second, I'm just sharing the screen. Just be in the class. From the last session, we have started the civil drafting. So, we have discussed about the basic aspects of the civil drafting. Okay, and I have shared you the PDF of the same also. Today, we will start with the very first part of the civil drafting, that is the plaint, how to draft the plaint under the CPC. I think the law students who are pursuing the BA, LLB, or the law graduates, and everyone entirely will be acquainted with the term plaint in the civil proceedings for filing your thing
Yes,
with
ma'am.
for filing your thing, or we can say we need a plaint, means via medium or via the thing we want to acquainted the court with the facts. So, and the pleadings are just really totally upon the plaints and its ingredients. Before just directly jumping onto the format of the plaint, how the plaint is being drafted under the CPC, I would like you to please acquainted with another thing, that is the what the plaint is. So that is also very important to discuss before that. So plaint is a and a second most important thing, I think I have not shared this draft in the group. I will share as soon as the class is over. I will share this draft of plaint under CPC and the plaint notes itself. So just it's a I will share both the things in the I will share both the files. Okay. Now the thing is, my screen is visible to you all?
तो मत बता
Shritar, please mute yourself.
देख मेरे पेट में बच जाती है बातें बाकी में मैं नहीं कह सकती
Wait for a second. My screen is visible. Shritar, please mute yourself. Wait for a second. My screen is visible to you all?
No, ma'am, no, ma'am.
Okay, wait. It was displaying actually due to some network glitch. It just disappeared. Is it visible now? Format of plaint under the CPC?
Yes,
I hope
ma'am.
it is visible now. Okay. So just wait for a second. I'm just sharing. I will share this with you all also. As soon as the class is over, I will share this with you all also. Okay. Now the thing, first thing comes in the mind, that what is the plaint particularly. So plaint under the CPC is it's a kind of a, we can say, the basic or the platform or the foundation on which the whole of the CPC trial, or we can say whole of the we can say all of the CPC procedure, the court proceedings and everything just rallied upon. So plaint is what? Plaint we can define that it's the purpose of the plaint is just under the we can say law is to provide the court with the necessary information, that what are the things happened, what are the facts, or what are the key initiatives, and the content are just like they are governed by the specific rules, they are governed all by the specific guidelines under the CPC. So this is what the basic the plaint is. A plaint is a kind of a initial stage where there is a commencing of the legal action when the plaint is being suit is being filed in the court. Now the cause of action is given, if there are relief shortage, the jurisdictional information, they all are given under the plaint itself. There are another factors also, that is as per the law, what the as per the CPC what the law is. So order number 7 particularly deals with the plaint. Order number 7 under the CPC Civil Procedure Code, the plaint is given. So when we talk about the cause of action means first of all the legal theory, that what are the facts and why the plaintiff thinks so that he is harmed, and why there is, what are the kind of a legal remedies that are being available. Now under the order number 7 of the CPC, the word plaint is defined, and there are certain rules, there are certain regulations, there are certain aspects that are being covered. So when we break down all the rules of the order number 7, then there comes is just like rule number 1 to 8. that particularly define that what are the specific details that must be included. I have mentioned everything in the PDF, and that will make you easy to learn. Now, rule number 9 of order number 7. Here, what the rules we are discussing are telling us about the all the provisions of the plaint that is given under the order number 7. So, rule number 1 to 8, that okay, these are the specific details you need to be included inside the plaint. Next is rule number 9. It particularly tells that how the court should admit the plaint. Sometimes the plaint is also rejected, and I will tell you that when the plaint is rejected, the plaint is rejected if in anyhow sorry for the background noise. Actually, I'm at my mother's house, that's why I'm somewhere else now, that's why. Okay, so rule number 9 that tell us about how the court admit the plaint, or sometimes without, if the plaint is not complete, or if the plaint does not prepare as per the rule number 1 to 8, then the plaint get rejected. Now you don't want to do. Now comes the rule number 10 and 10A and 10B. So 10A, 10B is just the kind of a rules that particularly tells about what happens if the plaint in CPC needs to be returned and how parties should properly appear. Means that the plaint is not thoroughly rejected or it's not thoroughly denied, but the court asks them to just, okay, these are the certain changes you need to just be mentioned or just to be done, introduced in the plaint, and after that we will admit this. So the rule number 10 to 10A, 10B talks about the same. Now comes the another thing, that is the rule number 11 to 13. Rule number 11 to 13 means there are certain rules layout that situation in which the court particularly reject the plaint. So rule number 11 to 13 is, I was discussing earlier also, rejection of the plaint particularly depends upon the facts, like the plaint is not prepared as per the rule number 1 to 8, or even after, as per the court asks as per the rule number 10, 10A, 10B, that okay, these are the changes required in the plaint, and the plaint is written, then also parties didn't didn't appropriately done with the aforesaid changes. So as per the these things under rule number 11 to 13, the plaint are being rejected, and the most of the time the plaint is rejected because it's not appropriately prepared. That is the main reason. So by drafting the plaint, you have to be very particular, because it's a civil drafting. You have to be keenly just to be like, okay, these are the things to be mentioned this way, facts are to be mentioned this way, parties relief claimant should be mentioned like this way. I will discuss these things in detail in the upcoming presentation in today only. Now comes that the section number 26 of the civil procedure code is also important. Why is it important? Because it says that every lawsuit has to start with the presentation of the plaint. As we already know that the lawsuit will start with the presentation of the plaint. So plaint is kind of very essential when you start a case in the civil court. Now comes the very important aspect when we discuss about the drafting. It's the content of the plaint. One who is just drafting the plaint, it's just like a legal document. So the specific information must be there, and the information must be valid. Information must be specific, unless it wouldn't be considered. So rule number 1 to 8 of the order number 7 of the CPC is just like we will define or break down the particular rules 1 to 8 into the particular content of the plaint that are being given under the CPC. So you have to just keep in mind when you are just preparing any kind of a plaint under the CPC. First of all, you have to mention that what is the name of that civil court or the commercial court where your lawsuit is being filed. Here lawsuit word is synonymous with the plaint itself. Meanwhile, any student regarding the CPC, if have any doubt, then please put in the chat box. I will just go through the session. Then I will take each and everyone's query regarding the CPC and any other law. If any of the participants have any query, any other law, then please mention in the chat box. We'll take all the query at last. Now comes what? Now it's when we discuss about the rule number 1 to 8, that every time it's been asked that as per the rule number 1 to 8 of order number 7, the plaint must be prepared. So upon the breakdown of the rule number 1 to 8, it's just like as you seeing upon the slides also. Gives a thumbs up if the slides is being visible to you all, because what I am discussing here is everything mentioned upon the PPT. I am just Okay, thank you. Yes, so now comes that first of all, the name of the civil court of the commercial court means that where your lawsuit or the plaint is going to be filed. First of all, very clearly, it's also being mentioned in the civil criminal proceedings also. Name of the civil court, then followed up by the plaintiff information, including name, address, description, means following XYZ, son of a daughter of this person and resident of this person. Defendant name, their guardian name or the father name, mother name, residence, and then little bit description. And if there is any health issue, any disability, then if the plaintiff has particularly any health issue or the disability, then that should also be mentioned. Now given the thing that is the facts. Facts means that give rise to the cause of action and where this cause of action occurred. Though we have to mention that place, also locality, also the okay cause of action occurred here. Next is that the certain facts that help determine the court jurisdiction, because court jurisdiction, like for example, this was occurred in the XYZ area of the particular district, so the court has the jurisdiction to take up the plaint and to sort the matter. So this is very important. Next is information about the relief or the remedy that you are seeking. That because the plaintiff is filing, the person who filed the plaint is known as the plaintiff, and the other person is known as the deponent or the respondent. These are the basic thing. I think you must be acquainted with. Okay, the plaintiff has filed, the person filing the plaint is the plaintiff. So seeking any kind of a remedy or the relief, so that must be given. That information must be put forward. Next is to set off a portion of the claim, the amount allowed, that must be just like stated. Okay, this is the portion of the claim that is just required and that should be stated. Value of the subject matter of the suit, or then not just for the jurisdiction but also for the suit. Most important thing, that the plaint is rejected if the verification by the plaintiff and the oath is not given. If there is is an absence of verification under oath, means the affidavit is essential to file. If the affidavits are not there, then the plaint will be rejected. Verification by the plaintiff under the oath will be just like need to be presented. Then these are the details that is making plaint very essential in the lawsuit in the civil and the commercial courts. And rule number 2 also specifies that they must state the amount of money they are seeking from the defendant. Now there is a thing like a return of the plaint. Return of the plaint is under section number 19A. Section number 19A is also mentioned upon your slide. I think it is visible to you all. There is now such utility of going through the whole of the section what is saying through. According to this section, it means that if there is a lack of a jurisdiction, if any of the stage, if the lack of the jurisdiction arises, then does the court has the authority to return the plaint or not? So that are the point, that are the key things that are being discussed under the 19A. These are the practical aspects. When you go for the practice litigation, then you face these issues, but somehow these issues are not commonly stated. Now when the courts, if there is any issue arise, like lack of a jurisdiction is there, or where to decide the final matter in the lawsuit and any proceedings, then the second paragraph of 57, section number 57 of the act must be followed. So that's another thing. Now for that purpose also, in the limitation act 1877 is also being considered. So these are some of the things, but important part being discussed during the drafting of the plaint is there's a rejection of the plaint. So there are certain instances where the plaint may be rejected, and very important, because rejection of the plaint hold more relevancy than filing of the plaint, because once you file the plaint, and if it admissible by the court, then only your suit will be just like okay, going for the upcoming trial and so on. But if there is a rejection of the plaint, then those instances may be non-disclosure of cause of action. So the court may reject the plaint because it's impossible to prove the harm suffered by the plaintiff. Next is the if there is a case also for the same SNP Shipping Services Private Limited. I think during the CPC you might have studied this case, because this case is every time asked in the academics, SNP Shipping Services Private Limited case. So next is the undervaluation of the relief. Next is the improperly stamped documents, lack of the legal basis, failure to submit the duplicate copies, non-compliance with the rule number 9 of the CPC. Now these are the certain aspects that, there is another thing, that is the plaint is not verified on the oath. So if the plaint is not verified on the oath, then also the plaint are being rejected. Now comes what? The format of the plaint and the topic of today's session. Till now, I think no one have any doubt regarding the same. If no doubt, then please give us a thumbs up. We will start now with the how to draft the plaint. And many of the students have shared me the bail application and the anticipatory bail application also. Today we'll try to give you the one task of drafting a plaint. Okay. Now we will come to the another aspect, that is the form of the plaint, how the plaint must follow a specific format, or what are the essential parts. So when we discuss about the plaint, okay, one more thing you have to be just keep in mind, just that when you were discussing about the please shut the door. When we were discussing about the criminal drafting, so in that case there was no as such particular criteria or the rules regulations you are bound by. You are just like in the criminal proceedings, you are just like bound by, okay, these are the facts, these are the things happen to the victim, the aggrieved party, or these are the things, these are the charges. And moreover, there is a crucial role of the investigating officer also, and the charges being framed during the investigation, what the things being came out and so on. But under the civil proceeding, na, it's just been like everything you have to mention in the plaint only. So plaint in the CPC role plays a very crucial role, and you have to be very particular about what are the things you are laying down in the plaint, you are mentioning there, what are the aspects, what are the format, and what are the things you are taking into the this for seeking relief from the court. So there is a particular format that the plaint consists of the three essential parts. Number one part is the heading, followed by the title, the body of the plaint, and the relief that is being claimed by the plaintiff. So we will discuss all these parts in detail one by one. First of all is the heading and the title. Heading and the title is just like that include the name of the court. Name of the court is where the suit is being filed. Okay, it's not necessary that the name of the presiding officer, but only it's just like the honorable court of district judge Indore, on honorable court of district judge Moradabad, and so on. Next is you can mention it like this: honorable court of district, honorable court of district judge, district judge Delhi, Haryana, Delhi, or any of the city. Okay, any of the district. Now comes the parties, and there are typically two parties are there. Everyone is acquainted with. Plaintiff for the defendant. Defendant is also known as a deponent. So if or the respondent. If there is a sometimes term respondent or the deponent is mentioned, then you have to be just like, okay, this is the synonym of the defendant. You don't be bother or panic like, oh, who is this deponent here? Who is this respondent here? But there can be more than one plaintiff, there can be more than one defendant, and so on. So the plaint in the CPC is providing all the necessary particulars about the parties, particularly their name, their guardians or the parents' name, father name, their ages, any other detail for their required identification that is being mentioned, and their residential addresses. So these are the things that must be mentioned. If the multiple parties are there, then they must be mentioned, and they must be mentioned as per their respective roles. So and now comes the title of the suit. Title of the suit is means that what is the particular reason that is being bringing out to matter and indicate the court's jurisdiction. Now comes the body of the plaint. Body of the plaint is divided into the two parts. That is the first part dealing with the formal part. Formal part in which we will mention that, okay, that this is the date where when the cause of action occurred, and the date is very crucial because the date that is being mentioned will only specify or determine whether the lawsuit is being filed within the specific time period, or this is known as the period of limitation. So okay, this is the time period, and limitation period is particularly for the appeal application, especially. Now comes the jurisdiction. Jurisdiction means that the establish the court pecuniary and the territorial jurisdiction over the subject matter of the suit. The pecuniary means the financial, and the territorial means the geographical jurisdiction. Next is the subject matter value. The value subject matter should be properly stated, essential for determining the court's pecuniary jurisdiction for calculating the court fees. Next is the statement regarding the minority. If they are the case, if any of the party that is minor, then there should be the particularly mentioning. Next is like minor means any of the party is minor. Then on that we have the legal representative might be there. Next is the representative character of the plaintiff is representing others such in such class actions. So the legal representative, this should be indicated. Next is the if there is any reason for claiming the exemptions, then it's also like the reason for should be clearly explained. Now it's like the substantial portion. Substantial portions means that is the essential facts on which grounds the plaintiff is pursuing the cause of action, or there are certain another grounds also, legal grounds also, for the same. Now comes the there can be the the important thing is that I have mentioned in the last point also, multiple plaintiffs and their cause of action are not joined, they can also be clearly indicated in the plate. Another thing is that the relief is a very again a crucial part, means it specifies precisely what is they are seeking from the court, and what are the damages or the specific performance, if there is a specific performance of the contract, if there is any injunction to prevent certain cases or any kind of a relief. And it's very vital to state the relief clearly and accurately, because claims what are being made under the CPC can't be altered later, changed later, or they can't be just like we want to supplement something or not through the oral proceeding. No, they can't, because whatever the being asked or mentioned in the in the plaint, that the court will work upon the same. Signature and the verification at the end, the signature should be very placed and the oath must be given, the facts affidavit must be filed. Verification processes means that the personally verified that they on their knowledge or belief the paragraph that the things that are being mentioned under the plaint are true to their knowledge, and so on. So this is what all about the plaint particularly. Now I will share the another PPT that will talk about that. Wait for a second, I'm just sharing another thing slide also that will talk about the format. Meanwhile, if anyone have any query regarding the same, please put in the chat box. Now we will this was particularly the law talking about the plaint. Now I will share what is the format of the plaint for a second. Screen is visible? Okay. And one question, madam, what is cause of action? Cause of action means on which date you start feeling that okay, this is the mishap happened to you, on which date the thing happened, or the on which date some mishap is there, that is the cause of action. हम इसका बेसिक सा एग्जांपल भी अभी हम देख सकते हैं अनमोल, जैसे फॉर एग्जांपल मैट्रिमोनियल डिस्प्यूट है। मैट्रिमोनियल डिस्प्यूट में आपको पता होगा कि सिविल और क्रिमिनल दोनों तरीके के सूट फाइल होते हैं, सिविल में भी फाइल होते हैं, क्रिमिनल में भी फाइल होते हैं। जो डाइवोर्स का जो हिंदू मैरिज एक्ट में सेक्शन नंबर 13A में जो डाइवोर्स का सूट फाइल होता है वो सिविल नेचर का सूट फाइल होता है। अब उसमें क्या है कि फॉर एग्जाम्पल कोई पर्सन ए है, उसका मैरिज पर्सन बी के साथ 1 नवंबर 2000 को हुआ है, 2020 को हुआ है, और वो आपके 1 दिसंबर 2020 से सेपरेट हो गए हैं और अभी आ चुका है आपको 24। तो कॉज ऑफ एक्शन कब अराइज हुआ कि वो 1 दिसंबर से सेपरेट हो गए हैं, उनका जो मैट्रिमोनियल बॉन्ड था वो डिसॉल्व हो गया है। तो दैट इज व्हाट द कॉज ऑफ एक्शन means on the date particularly when the when it's just like okay, you are being harmed, you are being damaged, or the things happen to you, that is cause of action. I hope Anmol you got it. Okay. Now, if anyone have any other query, then please put in the chat box. Okay. Now comes the another aspect, that is that is the format of the plaint. Format of the plaint is just like any other thing. So it's a specimen, and the format plaint is accompanied by list of documents following the wakalatnama, following by the affidavit, followed by the any other supplementary documents or the evidences. Okay. Now there is a like duplicate plaint is also being sometimes filed. So a specimen is this like for example, as we have discussed in the law also, that particularly name of the court or name of the jurisdiction or name of the court must be mentioned. So it's like we have filed in the Saket Court Delhi, that mentioned in the civil court of the civil just Saket Delhi. Suit number is this and the date of institution is this. This is a very clear, very precise format. I will share you. Then it's another thing is that for example, first of all we have to mention the plaintiff, then we have to mention the defendant. So A son of this, resident of this, versus B son of this, resident of this. So A is the plaintiff and B party is the defendant or the respondent. Now we will mention that what's the subject matter. Subject matter is specific performance of the contract. Okay, one question in your mind will be that what kind of a nature of the suits or matters are being discussed under the civil procedure code. So suits related to the matrimony, suits related to the specific contracts, suits related to the partnership act, company law suits are sometimes also filed under the CPC. Okay. Now comes the another part. That another part is that the plaintiff respectfully show it. Above named plaintiff respectfully show it that the plaintiff is government servant. Now they will provide their detail that what they do and what's the subject matter, why they want to, why they approach the court, and what's the cause of action is there, and what are the legal reliefs they are seeking. We will discuss the plaintiff in detail now. The plaintiff is a government servant in the Delhi, and the defendant is a property dealer with the office in Saket. So these are the details about the plaintiff and the defendant both. Now, details of the property, which is that the disputed property is this. Okay, this is property is this, that is facing, that is being situated in the east to the road, and that is number 125 and so on. So, and the total property a value paid by the plaintiff to the defendant is 50 lakh, then agreed upon both the parties under the contract. Now what happened, as we have already mentioned, that it's a specific performance of the contract. So the suit is saying about same. So now the defendant has accepted 20 lakh rupees, but through the check number this payment made at the time of this, and now the remaining amount is 30 lakh rupees. That would be paid after the registry of the plot. Now what happened? The things were going good. Now what happened? The defendant is refusing to accept the remaining amount. Why? The defendant sent a legal notice also to the defendant with respect to the same. Defendant replied with an excuse to the transfer the plot. Now the cause of action arises. Why? When the defendant refused to convey the said plot to the plaintiff as per the terms of the contract. Now cause of action arises because abhi Anmol, you were asking what is cause of action. Read point number 6. Point number 6 is saying cause of action arose when the defendant refused to convey the said plot to the plaintiff as per the terms of the contract. If someone refuses, then happen when then you will be damaged, you will be harmed, then you will approach the court and the date and the time when you feel so the things happen to you, then only you are just like, okay, the cause of action arises. So this is what, when the harm or the damage being caused. This is in the case of a contract matter, so we are discussing it about here. Now the value of the subject matter of the suit is 30 lakh, and the same has been attached as a court fee for the purpose of the jurisdiction well within the period of the limitation. Means that the limitation period is doesn't over yet, and the no same cause of action instituted or pending. Means that no as such another case is being pended, or the suit is being instituted. Now this is what, these are the 1 to 10 points are dealing with particularly the main body. These are the plaintiff is a government servant. Point number 1 to point number 10, no suit on the same cause of action is instituted or the pending before any other court. Means we have to declare this also, and we will file the affidavit for the same. If the suit is any of the such suit is filed, then what would happen? The plaintiff will be rejected with the penalty. You have to keep in mind. Okay, now the prayer. The prayer is means what are the reliefs the plaintiff is seeking from the court, and what the court can grant the relief. So we will discuss it here in the prayer. The court is pleased to order the defendant to perform his part of the contract. First of all, the court will order like this: by accepting remaining amount and conveying the property. Next is plaintiff is allowed to dispose of the balance consideration. Defendant is allowed order to pay the cost of the plaintiff. Means what are the cost of the suits and so on. Defendant is ordered to pay. Defendant any relief the court may deem if the court may deem fit, think so and proper is there, then also the defendant have to pay. Then the signature will be provided, or signature will be advocate and the plaintiff both would be provided, along with the place and date. Place and date must be there. Here advocate signature is also important. Now comes the important term, that is the verification. Verification means that you have to just declare that I have the person A, name plaintiff, solemnly declare that what is stated in the paragraph number, everything, knowledge and the contents of are on the basis of information and the beliefs according to the legal advice from my advocate, which I believe to be true. This is the verification you have to give along with the signature of advocate and yours, the plaintiff signature along with the place and date. Now another thing is that you have to give the plaintiff on the oath. Oath means that you have to give the affidavit also. In the specimen, the affidavit is attached here with, and the when you go for the litigation, you file a plaint in the court, then the affidavit is given on the new pages, new extra thing pages that you have to mention it, and the photographs are also being pasted upon the plaint and the affidavit both for the identity. In the court of civil justice case, suit number this, date of institution this, matter is this, means that the plaintiff is a son of this, residence of this and all, defendant a of b son of this, resident of this, and so on. Affidavit means you are giving the particularly you are just giving them the things, facts, that declaration that what is being solemnly affirmed and declared, that what are being given or stated in the suit or the plaint are being well as per the your knowledge and belief, and you are well aware, conversant with the facts of the cases, and swear the contents of the affidavit. Next is the plaintiff's content are true and the correct and to the best of your knowledge, and doesn't repeat it here for the sake of brevity. So these are the things that you have to put in the affidavit, along with the place, signature, date, and of the deponent, and the verification is there, and verification must be there. Now it's a verification of the that person, deponent also, that plaintiff solemnly declares what is are true to my knowledge and are also stated on the behalf of my knowledge, that are being mentioned to be true, and so on. So this is how the plaint is overall drafted, and this is how the plaint is overall presented in the court. I will like to take each and every one's query. No one have any doubt till now? Brilliant. Yes, so this is all about the format of the plaint under the CPC. Now different courts follow different little bit of the changes in the format, that you can alter as per the circumstances of the cause of action or circumstances of the person plaintiffs who are there, or if the particular court is asking something to add or something to erase, then it's possible, but this is the specimen of the plaint. And anyone please have any query, then please put in the chat box, and we'll like to entertain all your queries. And rather than the plaint or the CPC, if any law student have any other query in the other law subjects also, then also please feel free to ask me. Would like to help you out in any manner I can. And if you got the format of the plaint, then please give us a thumbs up. I will share this both the things in the group as the class is over. Okay, Ashish. Okay. Yes, please. Only giving the thumbs up is not enough. You people are getting generally asking why is affidavit necessary. Lavi is asking. Wait for a second. I'm just taking your question. Generally asking why is affidavit necessary, because it doesn't state anything new. Affidavit is just you are giving the you are stating something on oath. You are declaring something. Affidavit means that you are stating, you are declaring. Yes, Lavi. And that's a court processor actually. Task regarding the drafting of the plaint. Yes, I will. Nishtha Shresth. Madam, what exactly is the Wakalatnama? Wakalatnama is like, you have heard the term power of attorney? Power of attorney, I think I must say everyone have heard of. Wakalatnama is just like an advocate certificate that, okay, this is the advocate representing you for the particularly civil suit. So that advocate files a Wakalatnama with whatever the suit is there. So that is your legal representative there on your behalf. The legal proceedings or the legal proceedings will be done on the behalf of you. You given him the handed over the power to take the legal action, to do the documents filing and so on. So for that proof or certificate, and the document is filed by the on the behalf of the advocate, that is known as the wakalatnama, or kind of a power of attorney itself. Task regarding the drafting of the plaint. Yes, Anmol, I will give the draft once I will done with the queries and so on. Yes, anyone, please ask any question. I just like to sort all your queries, because in the drafting you have to be just sort your doubts. Everyone having the samples, everyone having the barrack with themselves. Wakalatnama is annexed in the both civil and the criminal cases. Yes, wherever the advocate will file a new suit, a complaint case, or anything application, or there they have to file the Wakalatnama. Either is a suit or a civil case, or it's a criminal application. The advocate is representing you on your behalf in the court, na? So that's why. Verification affidavit is like giving oath. Verification, no. Verification is the another thing. Verification means that what are the facts that are being stated, and you and your advocate is signing that. That is the verification. Affidavit is like giving the oath. Yes, we are all together giving 3 times oaths. All are mandatory. Yes, Naginder. Every time it is mandatory, and this is the particular format that is being given by the Civil Procedure Code in the order number 7, rule number 1 to 19 particularly, ki you have to give all these aspects, and how many times they are asking you to, you have to, else your claim will be rejected. This is the particular format, na, that's why in the civil drafting, the all the formats are given in the form of a rules and the regulations, in the form of a law in the act only. That's why the Civil Procedure Code is much lengthy. I think CPC and the jurisprudence are just like the nightmare to the law student. But you will be shocked to know the fact that the jurisprudence and CPC are the most interesting one. You can't be just like, okay, books are this much heavy, or the 1,000 or 2,000 pages are there. But these both are the most interesting part of the law. Either is the jurisprudence, legal theory is there, or either is the CPC. Both are very interesting. No one is asking you to start studying the CPC from rule number 1 or the section number 1. Just go through the procedure and just follow the procedure, then start studying. And you will find it more insightful or more interesting than the CRPC and the criminal procedure. Oh, sorry, criminal law. What is caveat? Caveat is kind of a civil suit only. Caveat emptor is filed in the court. We'll discuss it later, caveat. I think its format in the schedule is also there. We'll discuss then caveat. Yes, ask and something another. Yes, yes. Or if you want to know the caveat till now, so I think we have discussed in a very early thing a legal notice. Legal notice. So legal notice just like a communication, a mode of a communication that is being done between the parties. No, so under the CPC also you can be just like, okay, it's like a mode of a communication, and it's just like to prevent any kind of a legal proceedings, or to prevent any kind of legal consequences. The parties are being communicated. So this is a kind of a caveat, and application is being filed. Kind of a legal notice, we can say, a synonym of the legal notice. Yes, Ravi. Anyone have any question? What? Madam, please tell me what the. Madam, please tell me what is the time limit for filing the contempt in the Supreme Court after the date of disposal in the High Court? Please go through the schedule of the Limitation Act, because as per the nature of the schedule, as per the schedule nature of the suit, then only we can decide that what is the time limit, and that is given under the Limitation Act, Naginder. There is, after the annexer is there of the schedules where the time limit is given. Schedule, let me check in which schedule it's given. Time limit is given in the schedule, in the schedule. I think schedule number 3 is there. Yes. What is rejoinder? Labib is asking rejoinder. Okay, rejoinder means rejoinder is a kind of a WS, particularly written statement. Written statement means whether if the parties arised any new fact, or any new issue, then what would happen? The CPC doesn't have the provisions for the say, but the court, if the court wish to, and court is just like considering the facts, then they can reply to the same. Rejoinder is kind of a particularly WS only. Written statement. When we will discuss in the lecture about the WS written statement, we will discuss it in detail also. Are the annexures also filed alongside the plaintiff if necessary? Annexures, what kind of annexures? Along with the plaintiff, you have to file a list of documents and the wakalatnama also, and along with that only. And it is necessary if you are talking about the wakalatnama and the list of the documents. So yes, it's necessary to file at the same time. Yes, anyone else have any question? No annexes relating to the fact. So yeah, listen. If there are certain annexes relating to the facts of the case, then you will file a list of the documents. Now, then in that you can mention, and you have to file it along with the plaint only. Yes, you have to file along with them. CPC is way part interesting because everything what is mentioned in the law, you have to just follow that. Just go with the law. Yes, anyone have any other question, or else I am giving you the task. I will put the task in the group also. You have to draft a plaint for the civil suit of a matrimonial dispute under the section number 13B of Hindu Marriage Act. Annexer, annexer and enclosure. Enclosure, I didn't. Enclosure means kind of a formal letter containing the thing. Annexer means what are the attachments or the things that are being accompanying by the legal document. And Nishtha, I will share the task in the group. Yes, I will share. Wait, I am just typing the task in the group only. No? Yes, meanwhile, anyone have any other question? Then please ask. Else we will meet tomorrow with another session. Class 10th notes, it's not in the group, it's missing. Srishti, class 10th was all about the pre-trial preparation. And pre-trial preparation, I have shared you in the detail with the class number 1 or 2, I think. That's why I didn't share anything related to the class 10th notes. Kindly refer to class 1 or class 2 notes, and in that all the pre-trial preparations are given. So it's not missing anymore, Shrishti. Yes, you people kindly open the PDF and go through the topics. Then you must be yourself will be acquainted with the. Okay, this is already, and this I have told you many times in the lecture also. Yes, Shrishti. Class 10 is all about the pre-trial preparation, so that is being shared earlier. Yes, anyone else had any query? Then please proceed. Else we will wrap the session and we'll meet you tomorrow with a new draft. That gives a thumbs up that you got the draft of the plane today. Okay, Nabi Shrishti. Okay, Nishtha. Okay. Legal Vidya, if are you there? Then please wrap the session, or else everyone, thank you so much for joining. And I will share the task in the group.
Thank you so much, ma'am. Thank you so much,
Thank you.
participant, for joining. Good night, everyone.
Good night, everyone.